Good morning, Mr. Pretorius.
Morning,
Good
Chair.
morning, everybody. Yes.
Chair, the program for this week is dedicated to term of reference 1.7.
Yes.
That is the closure by the banks of Gupta-owned or Gupta-related bank accounts. The team is led by Advocate McQuena, who will do a short opening,
Yes.
and will today lead Mr. Ian Sinton of Standard Bank. Other members of the team will lead ABSA, First National Bank and Nedbank during the course of the week. If we may ask for an indulgence to start on Wednesday at 9:30, Chair, so that will allow the expert Dr. Kaufman to testify thereafter and complete his evidence on Wednesday.
Okay.
For the remainder of the week, that will depend on preparation of witnesses, and we will revert to you during the course of the week in that regard.
Yes, and of course on Thursday, I think there is that one application by Ms. Lynn Brown that we postponed to Thursday that I'll deal with, but that shouldn't take much time.
Yes.
No, that's in order. Thank you very much. May I also take this opportunity to announce that tomorrow morning we will have to start a little later than normal. Let's start at 11:30 tomorrow. The reason for that is that I have to hand down a judgment in the Constitutional Court at 10 in the morning. So I would like to allow enough time for me to finish that and then come over. So tomorrow we will start at 11:30. Thank you.
Thank you, Chair.
Thank you.
Mr. Chair,
Mr. Mkwena.
during this session of the inquiry, as pointed out by Mr. Pretorius, the Commission will be focusing on the term of reference 1.7. For ease of reference, Mr. Chair, and in order to meaningfully address the issues emanating from this term of reference, we have prepared a bundle which we also propose to mark it as Exhibit H1.
I've got this bundle and it will be marked as Exhibit H1.
Yes. Mr. Chair, in order to assist the Chair to navigate through the bundle, it contains, the first documents of the bundle contains a notice of motion, founding affidavit, as well as annexures, which were filed in a matter initiated by the then Minister of Finance, Mr. Gordon, against the Gupta-related companies. And you'll see, Mr. Chair, that from page 97 to page 165, you will find the witness statement and the annexures submitted on behalf of Standard Bank. From page 166 to page 185, it is a witness statement and annexures submitted on behalf of FNB. And from page 186 to page 201, it is a witness statement submitted on behalf of ABSA. And from page 202 to page 207, it is a witness statement submitted on behalf of Nedbank. For completeness, Mr. Chair, may we remind ourselves of what this term of reference 1.7 entails. Mr. Chair, it provides as follows. Whether any member of the National Executive, and including deputy ministers, unlawfully or corruptly or improperly intervened in the matter of the closing of the banking facilities of Gupta-owned companies. The genesis, Mr. Chair, of this term of reference can be traced back to the application that was initiated by the Minister of Finance, Mr. Goran, at the time, against Oak Bay and other Gupta-related companies. That application was brought before the High Court under case number 80978/16. It's now reported in our law reports as the Minister of Finance versus Oak Bay Investment, 2018, volume 3, SA, on page 515, GP. In the aforesaid application, Mr. Chair, the Minister sought a declaratory relief to the effect that he is not by law empowered or obliged to intervene in the relationship between the banks and its clients. And as evident, Mr. Chair, from the bundle H1, with particular reference to page 1, you would see that the banks, including the governor of the Reserve Bank, the registrar of the banks, were cited as respondents in the aforesaid application. ABSA, FNB, Standard Bank, and Nedbank also filed affidavits in that application. For the purpose of addressing the term of reference 1.7, we did not deem it necessary at the stage to include those voluminous affidavits which were filed by the parties, more so that the averments which are contained therein, to a larger extent, Mr. Chair, they do find themselves also in the witness statement which are submitted on behalf of the banks for the purpose of this inquiry. However, should they be required, we will make them available to the Chair. In order to provide context to the issue to be canvassed in relation to the term of reference 1.7, we propose, Mr. Chair, very briefly, to highlight some of the factual averments advanced in the Minister's affidavit. We do so because they foreshadow the evidence which we intend leading during this session of the inquiry. The Minister, in paragraph 3 of his affidavit, for reference, Mr. Chair, you'll find it on page 10 of Annexure H1, set out the purpose of the application in the following terms. He states that this is an application for declaratory relief arising from a dispute relating to the powers of intervention by government in relation to the closing of private clients' accounts by registered banks. This dispute has arisen in circumstances which have considerable importance for the operation of the banking sector of the South African economy and its regulation by government. The related controversy has received both national and international attention, and it is clearly in the public interest, the interest of the affected clients and relevant banks and employees of both, that it be authoritatively resolved. In paragraph 7 of the Minister's affidavit, the Minister refers to the public announcement which was made by Oak Bay to the effect that its banking accounts had been closed by the banks and that its auditors, KPMG, and its sponsor on the Johannesburg Stock Exchange, that is SASFIN, have similarly terminated their relationship with Ogbay. Lastly, Mr. Chair, by way of background and context, we find comfort in paragraph 19 of the minister's affidavit. Without having to read it, I'll summarize it for the chair. In that paragraph, Chair, the minister laments the continued pressure exerted upon Ogbay, exerted by Ogbay upon him in order for the minister to intervene with the bank's decisions. He further highlights the regulatory scheme upon which the banks operates and a need to respect the autonomy of the banks. That theme, you'll find it throughout the affidavit of the minister and also in the affidavits of which was filed on behalf of the banks. The Gupta-related companies, Mr. Chair, accepted the decision of the banks to close their accounts as being lawful, and that is apparent if one has regard to the letter which was written to the Minister of Finance by Mr. Nazim Hoa, the CEO of Ogbay. You will find that letter, Mr. Chair, on page 1 to 2 of the bundle, and it's marked as Annexure SB3. Yes,
Yeah.
Mr. Chair. You'll find on paragraph 3, unnumbered paragraph 3, the following is recorded. Given the time challenges facing us during the meeting and your suggestions around legal remedies, I thought it prudent to place on record that following detailed discussions with several legal advisors, we are of the strong view that given the contractual rights the banks have, any legal approach may indeed be stillborn. The banks have each said as much to us in their correspondence to ourselves. As mentioned this morning, we have also been told by the key regulators such as the Banking Ombudsman and the National Consumer Council that our matter falls outside their jurisdiction. That advice, Mr. Chair, was indeed correct, more so if one has regard to the Supreme Court appeal judgment in the matter of Breedenkamp versus Standard Bank, 2010, Volume 4, SA, on page 468. You'd recall, Mr. Chair, that this was an appeal which was brought by Mr. Breedenkamp pursuant to Standard Bank having closed its account. The Standard Bank closed the account after it became aware that the United States Department of Treasury Office of Foreign Assets Control, abbreviated OFAC, had listed Mr. Breedenkamp as a specially designated national. This was as a result of certain suspicious transactions which were noted, and also it was as a result of the reason that Mr. Breedenkamp had ties with the Zimbabwean government, and he was alleged to have been providing financial support and logistical support to the regime, which was seen to be anti-democratic principles. Those were the bases upon which Standard Bank decided to cut ties with Mr. Breedenkamp. The concerns of the banks, of the Standard Bank, Mr. Chair, are captured neatly from paragraph 17 and 18 of the judgment, simply for noting without having to read them. And Mr. Breedenkamp did advance a number of challenges including the constitutional challenges to one of the terms in the contract, to the extent that it was unconstitutional for Standard Bank to simply terminate the relationship without affording them a hearing, and therefore that clause was unfair. Ultimately, the court came to the decision that it was indeed within the rights of Standard Bank, having regard to the contractual scheme and the client-bank relationship, that it was entitled to terminate. And those are the bases upon which Standard Bank, even when there was a pressure which was exerted upon it, it relied on proper authority for its decisions. And I suspect that the other banks also followed suit. Mr. Chair, having outlined the parameters upon which we foreshadow the evidence to be led on behalf of the banks, I will be leading the evidence of Standard Bank, and Ms. Zintle Buthelezi will be leading the evidence of Absa Bank, and Ms. Refilo Molefe will be leading the evidence of FNB, and Ms. Kate Hoff-Meyer will lead the witness from Nedbank. Mr. Chair, we are ready to proceed with the evidence of Mr. Sinton.
Thank you, Mr. Mkwena. The registrar can swear in the witness or do an affirmation, as the case may be.
Yes, Mr. Chair, prior to swearing in the witness, we may also state for the record that the notices to the implicated parties were duly dispatched within the time periods. We received correspondence from the attorneys of Mr. Msebenzi Zwane as well as Minister Oliphant, to the effect that they are still consulting with their clients and they might in due course approach the chair with an application if so desired.
Okay, thank you.
Please state your full names for the record.
Ian Hamish Scott Sinton.
Do you have any objection with taking the prescribed oath?
No.
Do you consider the oath to be binding on your conscience?
Yes.
Do you swear that the evidence you will give today shall be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. You may proceed, Mr. Mkwena.
Mr. Sinton, on the 13th of December 2016, you deposed to an affidavit in the matter which was brought by the minister against Oak Bay and other Gupta-related companies. Is that correct?
That is correct.
Yes. And in order to assist this commission, you also submitted a witness statement.
That is correct.
Yes. May I refer you to the bundle before you, which is marked H1, and if you may turn to page 97. That document runs from page 97 to page 165. Are you there, Mr. Sinton?
I am.
Yes. Is that the witness statement that you have furnished to the commission?
It is.
May I refer you to page 117? Is that your signature?
It is.
Do you confirm the contents of your statement under oath?
I do.
Could you briefly share with us, Mr. Sinton, your employment history within the banking sector?
Yes. Prior to 2002, I practiced as an attorney in South Africa. In 2002, I was recruited by the Standard Bank into their corporate and investment banking division as the head of legal, and I have been within Standard Bank in the legal department since then. In about 2008, I was appointed as Group General Counsel, i.e., I was responsible for the management of legal risk throughout the Standard Bank Group globally. As from that date, I retired in June 2018 this year, and I currently am retained by the bank to deal with certain outstanding issues that were pertinent at the time of my retirement.
Yes. And at the time when you deposed to an affidavit on behalf of Standard Bank in the Oak Bay litigation, which position did you occupy?
I was then the Group General Counsel.
Yes. And what were your functions? What did that portfolio entail?
As I mentioned, it entailed the management of legal risk throughout the group, which obliged me to ensure that as a Standard Bank, as a banking group, we have banking operations in about 18 countries around the world, and we had to ensure that within those countries, the legal requirements of the laws of the land, if it were all complied with, and then it also obliged me on issues where there are significant what we call legal or franchise risk were escalated to me, and I was obliged to assist the executive of the bank or the banking group in dealing with those legal issues.
Yes. You mentioned that you had to deal with issues that had to mitigate any risk within the South African economy. Can you explain, just expand to us what risk are you mentioning? Are you referring to?
Well, there's obviously multiple legal risks. It's compliance with all statutes is the obvious one. Ensuring that all agreements we enter are compliant with the common law, that we don't conduct ourselves in a manner which attracts penalties or censure. Those are the types of risks that we manage.
Now,
I'm sorry, maybe Mr. Mukwena, you could raise your voice a little bit. If you could raise your voice a little bit.
yes.
And the witness's voice is raised, but for some reason, I don't know why, I missed some words. Maybe there's something wrong with my own hearing. So I don't know what you might need to do, Mr. Sinton, but try and articulate what you are saying as clearly as you can. I think your voice is at the right level, but I don't know why I'm missing some words as you speak. So just do the best that you can.
Thank you, Mr. Chairman. Perhaps I'll slow down.
Thank you.
Mr. Chair, I will adopt Mr. Malika's position when he looks at the witnesses. Maybe it might help. Could you explain, Mr. Sinton, to us the regulatory framework which the banks operate within? And please educate us about both the domestic and international instruments that the banks have to observe.
Yes, Mr. Chairman, obviously the bank is a company like any other company, so it is obliged to comply with all laws that apply to companies. So I won't really try and map those out. The ones that are pertinent, I think, to this commission are the Banks Act, obviously, because banks operate under the Banks Act, and then the legislation that applies in the context of suspicious transactions, money laundering, dealing in the proceeds of crime and corruption. The principal legislation that applies to us, well, in fact, applies to most institutions, but particularly to banks, is the Financial Intelligence Center Act. That act obliges us as banks to report all suspicious transactions to the Financial Intelligence Center. That is a compulsory obligation. Failure to report a suspicious transaction itself is a criminal offense. It's equally relevant, Chairman, that it's also an offense to disclose the fact that a suspicious transaction report has been made. So the banks have to be very careful when they make these reports to ensure that the fact that the report has been made is not disclosed. The second piece of legislation which is pertinent is the Prevention of Organized Crime Act. Now that, obviously, the main thrust of that act is to do with the combating of organized crime, but very importantly, it also deals with the issue of money laundering. And we understand that generally to be a prohibition on us as banks being in any way involved in facilitating money laundering or dealing in the proceeds of crime. The third piece of legislation pertinent, I think, is the Prevention and Combating of Corrupt Activities Act. We call it PRECA for short because it's a difficult description. And PRECA, in essence, as it applies to us as banks, is we're obliged to ensure that our systems, our banking systems, are not used to in any way facilitate corrupt payments, and to ensure that we don't become accessories of the fact in corruption. I need to mention, Chair, that as you would expect in statutes which provide for criminal sanctions, that knowledge is a factor that has to be present, knowledge of the facts giving rise to the crime. But in all of those sections, they have a virtually identical definition of knowledge or knowing, and that is actual knowledge of the facts or a reasonable suspicion of the facts, i.e., if a court finds that a reasonable banker should have been suspicious but transacted nevertheless, that remains an offense on our interpretation of the legislation. We have regrettably experience in dealing with international criminal justice systems in the United Kingdom and the USA. There they talk about this concept of willful blindness. People who are willfully blind to wrongdoing can be as guilty as the wrongdoers themselves. That's the view they take, and we interpret our legislation to make the same provision. That's the regime as it applies in South Africa, on our understanding.
Yes. Now,
Before you proceed, Mr. Mokoena, I just want to say both of you, whatever you did, I can now hear both of you very well. So please don't change, so I can hear you very well now.
the Malika posture did come to the chairman's rescue.
It looks like it works.
It does. Mr. Sinton, flowing from your answers, could you please relate to the chair the adverse consequences which Standard Bank is likely to suffer in the event that it fails to comply with these international and domestic regulatory obligations?
Yes, first, Mr. Chairman, obviously in South Africa, failure to comply with the statutes would expose both Standard Bank and its employees to significant penalties. The fines are truly significant, as are the prison terms provided for, are really material. But equally importantly is that we as a bank, and in fact most of the banks in South Africa, are obliged in order to conduct the business of a bank to facilitate cross-border payments, i.e. to facilitate trade and investment across borders. We have to have banking relationships with correspondent banks around the world. We can't make payments on behalf of our customers to people from whom they've imported goods. We can't receive the proceeds from the export of goods if we don't have banks in the countries where our customers operate. Now, again, it's our experience that in most of the countries where we have correspondent relationships, there are similar laws to the laws that apply in South Africa. So whilst we in South Africa are very careful about who we do business with in the form of international banks to ensure that they do not expose us to contravention of our own laws, they in turn, as international banks, constantly monitor us to ensure that we don't expose them to corruption, money laundering, and in some cases the financing of terror. So we are very careful in all we do, not only to ensure that we comply with South African law, but we ensure we do it in a manner whereby we can't be criticized by our correspondent banks around the world for the manner in which we comply. Because the obvious consequence is they, as international banks, if they think we are not fully compliant, will terminate dealings with us. And that would have severe consequences for us as a bank and obviously for the country if the international banks determine that we are a risk.
Now, in turn, what will such a failure, what will be the effects of such a failure on the economy of the country?
Obviously, it would be highly detrimental if Standard Bank, for example, we're one of the larger dealers in United States dollars. We provide dollars throughout the African continent, not only to customers of ours in the commercial sector, but to central banks and governments. And if we were denied access to the United States banking system because of perception that we do not uphold sufficient standards as regards corruption, money laundering, and financing of terror, then that would be significantly damaging to our business. And obviously for the country would not be able to pay for imports or receive the proceeds of exports, etc., if such a calamitous situation were to arise.
May I refer you to page 99 of H1, with particular reference to paragraph 5 and 6, where you are setting out the background to the statement that you have actually furnished to the Commission. In those paragraphs, you say the following at paragraph 5, until 6 June 2016, Standard Bank had a banker-customer relationship with various companies in which various members of the Gupta family and Mr. Tutuzani Zuma held direct or indirect interest. In this statement, I will refer to these entities as the Gupta entities or Gupta and its associates. In paragraph 6, we're saying that Standard Bank gave notice on the 6th April 2016 to the Gupta entities of its intention to terminate the banker-customer relationship with them as from 6 June 2016, a notice period of 2 months. On the latter date, Standard Bank officially terminated those relationship. A list of the Gupta entities affected by this decision will be made available on request by the Zondo Commission. Now let me start with the last portion of your statement. Were you able to collate that information or to provide the list of those entities which were clients to Standard Bank?
Yes, I have such a list.
Yes. Mr. Chair, we beg leave to hand in the list and accordingly mark it as annexure, as Exhibit H2.
Thank you.
And now, from the list that we have...
Sorry, the document will be marked Exhibit H2.
Thank you, Mr. Chair. From the list that you have provided to the Chair, the one that is now marked H2, would I be correct that some of those entities are the ones which were cited as the respondents in the Minister's application against Ogbay?
That is correct.
Yes. Now, how was the notice dispatched to the Gupta entities? The notice of intention to terminate the banking relationship?
In each case, the notice would have been in writing in the form of a letter, and in each case, the representative of Standard Bank assigned to the management of the accounts would hand deliver it to the Gupta entities concerned, explain the content, and leave it with them.
Yes. Were there any discussions between Standard Bank and other banks prior to Standard Bank dispatching this notice?
None whatsoever.
Now, could you explain to the Chair the process which Standard Bank followed prior to it terminating or dispatching the notice to the Gupta-related entities? What process internally was followed by Standard Bank?
Yes, Mr. Chairman, obviously, because of the need to constantly be on our guard to ensure we do not inadvertently contravene any of the statutes which I mentioned by, for example, facilitating corrupt payments or dealing in the proceeds of crime, we constantly monitor media for adverse reports about customers. We also internally have ongoing relations with customers where if we see any suspicious transactions going through the accounts, we contact the client and say, you need to explain what's the source of the money, what's the application for this money. And we also then have a team of people who are dedicated to looking out for suspicious transactions using algorithms and similar technology, and to ensure that we fulfill our reporting obligations under the Financial Intelligence Center Act. So the process which we follow generally is when, through external media or internal information, we notice conduct on the part of a customer which might give rise to a suspicion that the customer is involved in something unlawful. We trigger a process of gathering all information that we can about the customer, about the conduct, and we, in certain instances, we employ outside agencies such as Thomson Reuters and others to help us with the gathering and collation of this information. And once we think we have a picture of what really, of all the evidence that is available, we then, if it's compelling, in our opinion, take a decision to terminate the relationship. If it's not very compelling or perhaps ambiguous, we will then ask for an engagement with the customer and give the customer an opportunity to persuade us that the adverse information is unjustified. On either basis, we will then put the information so obtained before a committee of senior people who are deemed to be objective, i.e., who don't have a vested interest as to whether we continue the relationship or not, and that committee will make a decision on whether to terminate or not.
So, are you saying that whether or not Standard Bank would have a discussion with the customer before making the decision to terminate the relationship would depend on whether Standard Bank took the view that the evidence is compelling or not? And if it is if the Standard Bank thinks the evidence of wrongdoing or contravention of some laws is compelling, they won't discuss with the client. If Standard Bank thinks that the evidence might not be so compelling, it would then have a discussion with the client?
That is correct, Jim.
Why doesn't Standard Bank take the view that whether it thinks the evidence is compelling or not, it will give the client an opportunity to explain before making a final decision? Because obviously a decision such as that is quite a serious decision for the client.
Mr. Chairman, it depends on the circumstances. So, for example, if a client has been convicted of a criminal offense, we would not see any need to have a discussion about the effect of that on the relationship, the banker-customer relationship. But if there are simply unsubstantiated rumors or hearsay, then we would feel a need to engage with the customer to have the discussion.
In the case of a conviction, would you wait until all appeal processes have been completed, or would you make a decision even before any appeal processes are completed?
No, for us the test is from all information available, is there sufficient for us to suspect that our systems may be used for some other offense? And if we reach that conclusion, we will make a decision. We don't wait for there to be an actual conviction or the outcome of an appeal before we make a decision as to whether we wish to continue what is a contractual relationship.
Well, my difficulty, and Mr. Mokoena maybe was still going to deal with that, is my difficulty is with the position that where you think that the evidence against the client is very strong, you don't hear the client's side of the story, and yet you are dealing with a decision that could have serious repercussions for an individual or for a business. And I would have thought that it's an easy thing to do, to say, even if we think this client might not really be able to explain this thing, but let's hear what he or she has to say and then make our final decision, because this is a very serious decision that we might take against this client. So I'm asking those questions against that background. And you said that you made the example that if the client has been convicted, and I assume convicted of certain crimes, then you would not see any need to give that client an opportunity to explain. But you say that you won't wait for an appeal process. So I'm wondering what happens if there's an appeal process after you've made the decision and the appeal succeeds, and yet you made your decision on the basis, you didn't give the person a chance to explain on the basis that there was a conviction.
Mr. Chairman, I should mention, it frequently occurs that when we convey the decision to the client asks for to make representations about the decision, and those are always entertained, but we don't always, before we make the decision, invite those representations. That is the way we conduct things.
But what would you say to a proposition that it would be unfair for an entity such as a bank, which plays a very important role in the affairs of many people in business and their individual affairs, to make a decision such as that against a client without affording the client an opportunity to explain, even if the bank thinks there is a compelling case against the client.
I would say it's difficult to balance the obligation to comply with a strict prohibition under the legislation not to deal with any client where you have a suspicion of wrongdoing, with a corresponding obligation to actually have a process of engagement about whether or not the conduct justifies a suspicion. It would be for us a difficult exercise, but that is the way we do things at the moment.
Well, I'm able to ask you more questions on this because you are a lawyer. You know about the audi alteram partem rule. Banks are not government entities, but nevertheless, they exercise a lot of power, and their decisions could have far-reaching consequences for a particular business or individual. And I just wonder whether, to the extent that Standard Bank has adopted the position that you have articulated, that in some cases they won't give a client an opportunity to explain just because they think there is a compelling case against the client, whether Standard Bank can't be criticized then for acting unfairly in those cases. I'm talking now in general, I'm not talking about this particular one. In those cases where it decides to terminate the relationship with a client just because it believes there is a strong case against that client without giving that client an opportunity to explain and then make a decision thereafter.
Mr. Chairman, I think, well, I hope the legal answer lies in the Breedenkamp versus Standard Bank decision of the Supreme Court of Appeal, and there was an attempt to appeal to the Constitutional Court that was denied on the grounds that there was no prospect. But the decision there is that the banker-customer relationship is one founded in contract, and a bank, just like the customer can unilaterally terminate his contract with the bank can unilaterally terminate its contract with the customer. The bank is not performing an administrative or judicial function. It is simply saying, as your bank, I have a contractual right to terminate. I worry that you are exposing me to criminal conduct which I'm not prepared to risk, and therefore I choose not to deal with you. And in particular, in the Breedenkamp judgment, it made clear that no reasons are required. There's no obligation of the bank to give a reason. So I think once you adopt a position, there should be an audi alteram partem principle, and then a rational decision, etc. You're going beyond the contractual right of a bank to say, I choose not to go down a road that I think is unnecessarily risky for me.
Well, I'm sure that maybe at some stage there will be some argument on it, but if I were Standard Bank's client and Standard Bank decided to terminate our relationship, let's say for argument's sake, I've been with Standard Bank for a long time. We have been doing business together for a long time. And they form a view about myself or what they think I've done, and they then make the decision to terminate the relationship without affording me an opportunity to say, this is the explanation or this is not so. I would regard that as quite unfair. It may well be that, argument may be put up on various grounds, and you and I, being lawyers, might be aware of some of those grounds. But I would have thought that unless you are dealing with an emergency situation where there is no time to wait for an explanation because you have got to act promptly, unless you have that kind of situation, I would have thought that the bank would suffer no prejudice by saying, let's just hear what he has to say and then make our decision after that. You might or might not wish to comment on that. I'm just mentioning to you what's going on in my mind, and obviously I'm open at a later stage for arguments that might go either way.
Yeah, Mr. Chairman, thank you.
Mr. Sinton, let's attempt to ease the mind of the chair. The issues which the chair was probing with you, would I be correct that they were also addressed in the Breedenkamp Supreme Court of Appeal matter?
Yes, my understanding they were.
In fact, the argument advanced on behalf of Mr. Breedenkamp was exactly that how could the bank decide to close its account without affording it its opportunity to state their case first? Am I correct?
That is correct.
They also raised a number of constitutional challenge in relation to the express term of the contract, which permitted Standard Bank to terminate its relationship as it did. Am I correct?
That is correct.
And ultimately, the Supreme Court of Appeal also had to address issues pertaining to reputational risk as well as business risk, which entitled a bank in those circumstances to can terminate even without affording the client any hearing. Would that be accurate?
My understanding, that would be an accurate summary of the judgment, yes.
Yes. Chair, those issues were canvassed at large at the Brain-Gap matter. The relevant paragraph also is paragraph 64 of the judgment, but those questions that the chair has raised with Mr. Sintin were debated and were dealt with by the SCA.
You said the Constitutional Court didn't hear the matter.
It did not grant
Yeah.
Mr. Brain-Gap leave.
Yeah.
It must be on the ground, on the good reasons. Mr. Hauer, in his own letter, says that any challenge about the conduct of Standard Bank will be still born, and that was premised exactly on proper legal authorities, and there are also two opinions attached to the minister's affidavit, which we have also made them available.
It would help, if at all possible, to obtain the letter that is usually sent by the registrar of the Constitutional Court to the parties indicating the outcome of an application for leave to appeal. Sometimes the reasons given there will indicate that the decision of the Constitutional Court is based on the merits. Sometimes it will indicate that the decision of the Constitutional Court is based on something else. I am particularly alive to that because sometimes people think if an application for leave to appeal is dismissed by the Constitutional Court, it necessarily means confirmation of the correctness of the decision of the lower court on the merits.
Yes.
Whereas sometimes it's because of some other considerations.
Yes, Chair, we'll attempt to get that letter. All what we can point out to the Chair is that as the current law is the Brain-Gap matter in the SCA, and those issues were dealt with decisively. Mr. Sintin, are you able to share with the Chair the considerations which gave rise to Standard Bank having to close the Gupta-related companies? What informed the decision, if you are able to share with us?
Yes, Chairman. They are summarized in the affidavit that we deposed to in response to Minister Gordon's application in the High Court in Pretoria. But if I can, without reading that affidavit, summarize for you what they were. It really started with Absa Bank. It's important that it was reported that Absa Bank had elected to terminate all banking relationships with these entities in the Gupta Group. Now, we would obviously accept that Absa Bank is bound by the same laws as we are, so if they saw good reason to terminate, it put us on notice that we should look carefully ourselves as to what relation we had and whether we were at risk. And that more or less stimulated the commencement of the gathering of information. In no particular order, KPMG, who were the auditors to the group, then announced that they were terminating as auditors. You can fairly assume that an auditor would have far greater insight into the affairs of a company or group of companies than would the bankers. We typically only get given evidence about creditworthiness. So that was a concern, would have been concerning, requiring some investigation of the type required by the statutes. We then have Deputy Minister Jonas published the fact that he'd been offered a promotion in exchange for benefits. Our interpretation of that was that fell squarely within the definition of an offence under PRECA, and it was not insignificant that that account of what happened was published then on the website of National Treasury as an official publication by government. And we, in the world where we can't ignore suspicious transactions, we thought that was something that we ought to take cognizance of. We then had a former Minister of Parliament, Faiki Mentor, announced that there had been an attempt to offer her a role in cabinet in exchange for favors. And that for us was an issue of concern. Then Themba Moseko from the Government Information Agency or Service announced that he'd been instructed to assist Gupta-related entities. It so happened at the time that we had two companies in the Gupta Group who we provided services to that were in the media business. So if there was anything unlawful about that, we had to be concerned about whether they were then going to become party to some illegality. Then at the end of 2015, it was announced that Minister Zwane had accompanied a Gupta delegation to Switzerland to negotiate the purchase of the Optimum coal mine from Glencore. That on its own would have been concerning to us because Minister Zwane was the Minister of Minerals at the time, and in terms of the Mineral and Petroleum Resources Development Act, he would have been obliged to approve any change in control of that mine, and so to be part of the buyer's delegation, if it occurred, would have been concerning and give rise to suspicions. Similarly, it was reported at the time in the Financial Mail, which is a fairly reputable publication, that the Oak Bay group of companies had strongly denied that the minister had attended these meetings, had been part of the delegation, and yet a spokesman for the minister readily admitted that he'd been there, and that denial of what is a stated fact gave rise to suspicions on our part and concerns. Then it was reported in City Press that an executive of the Oak Bay Group had assisted a wife of the president to purchase a house in Pretoria for the price of exceeding 3.5 million rand by obtaining a bond from the Bank of Baroda, and that the bond had been repaid by a company within the group called West Dawn Investments. Now, West Dawn Investments was one of the companies with whom we did banking, and so that was a cause of concern to us. That same report mentioned that West Dawn had in fact bound itself with surety for the obligations of this particular. It wasn't the president's wife itself, it was a trust of which she was a sole beneficiary, sole trustee, and one of his sons was a sole beneficiary. That was concerning. The same report mentioned that the executive involved had denied any involvement, yet the media had obtained a mortgage bond document in which that executive signature appeared as a witness. So there again, the denial of any involvement by the executive coupled to the reference to a mortgage bond bearing a signature was grounds for suspicion. We then also had this company, we banked a company by the name of Estina. Estina was a company which was awarded a contract in the Free State Province to develop a farm, and there was wide publicity around how the farm itself had not been developed, but substantial sums of money being paid to our client Estina. When we investigated, we found that large proportions of that money were in fact sent to Dubai rather than being spent in South Africa on the farm. That caused, obviously, was suspicious on our part. After a company by the name of Tegeta had concluded the agreement to acquire control of Optimum coal mine, we received an email from Oak Bay laying claim to about 1.45 billion rands worth of funds that we held for a trust that had been established for the rehabilitation of the mine. We regarded that as suspicious. As a matter of law, these trusts, once set up for mine rehabilitation, are obliged to be ring-fenced in the process. The funds in the trust may be used for no purpose other than rehabilitation of the mine. Yet Oak Bay had asked us to transfer the funds to Bank of Baroda. All of that read together caused us to come to the conclusion that we were at risk as a bank if we continued dealing with these entities of either dealing in the proceeds of crime or facilitating money laundering or being involved in possible acts of corruption. I emphasize there was no finding on our part. We're not in the business of adjudication. We just said there's sufficient red flags here to make us wary of doing further business. I also mentioned that at the same time as as the collection and collation of information from the media was taking place, our own internal processes as regards the reporting of suspicious transactions to the Financial Intelligence Center were ongoing. And so we would ask our money laundering reporting officer to make an input as to say, we are reconsidering our relationship with these people based on this public information. Do you have private information based upon what you've seen going through the accounts that should give us cause for concern? And he most definitely told us that was the case. He couldn't, in terms of our policy and process, tell us what he had seen and what occurred, but he was able to say you ought to be exercise extreme caution in continuing to deal with these entities. So the decision was taken based on that we could no longer continue. All those combined factors that we should terminate our banking relationships.
Yes. Now, for completeness, may I refer you to Exhibit H2. It is a separate document handed to the chair. You have mentioned a number of entities, and I take it that some of them did have a banking facility with a Standard Bank. If you look at on page 1, item 1, you have Oak Bay Investment P2 Ltd, and it was banking with Standard Bank, am I correct?
Correct.
And you mentioned also the Gupta media houses. Would that be those that are reflected on item number 8, TNA Media P2 Ltd?
Correct.
If you turn over the page and you go to item number 14, it will be Infinity Media Networks P2 Ltd. Would that be one of those media houses?
Correct.
And you also mentioned Estina. Would I be correct that it's also reflected as one of your customers on item number 27?
That is correct.
Yes. Yes. Now, I also need to deal with you, to converse with you, Mr. Sinton. You have now informed the chair about the consideration that led to the Standard Bank having to terminate its banking relationship with those Gupta-related entities. I need to deal with you with the events that took place subsequent to the termination of the relationship. You are providing that context in paragraph 7 to paragraph 9 of your statement. Now, could you, in your own words, inform the chair what was Oak Bay's reaction after the accounts were terminated?
I suppose from a public point of view, Oak Bay and its subsidiaries embarked upon a media campaign to dissuade the banks to, induce the banks to reverse the decision. There's, I think in my witness statement, I attach a copy of an advertisement whereby the chief executives of the 4 banks were called upon by name to reverse the decision. And the reason given was that it was detrimental to to the well-being of 7,500 workers at in the Oak Bay companies. That was the public campaign. Privately, we received a request for our chief executive to attend a meeting at Luthuli House with the ANC to account to them for why we had closed these accounts. And then separately, we received a request from a committee which was described as an interministerial committee of cabinet to account to them for why we had closed these accounts.
Now, despite those private invitations that the bank had, are you aware of any application which was brought by Oak Bay and the Gupta-related companies in order to reverse that decision before a court of law?
We're not aware of any such application. One was threatened but never proceeded with. We don't know of any that were actually brought.
Before you proceed, Mr. Mkwena, Mr. Sinton, you have said that after Standard Bank had closed the accounts of these entities, you received, I don't know if it was a letter or a call to have a meeting with the ANC at Luthuli House, and also what was referred to as an interministerial committee. I assume that's the one that was said to have been, or at least at some stage, approved by cabinet. Now, I take it that prior to this occasion, when you closed these clients' accounts, you had a number of other occasions when you closed clients' accounts for more or less similar reasons, or not?
Mr. Chairman, yes. Although we do close accounts from time to time, it's not a frequent occurrence. In fact, I think when we did our research before those two meetings and we established it in the year of 2015, I think the total number of accounts closed for these reasons. The reasons other than concerns about corruption and money laundering, but where our concerns relate to corruption and money laundering, there were only 6 or 7 accounts were closed.
What was your, or Standard Bank's reaction to being called upon to the headquarters of a political party to account for a decision relating to a client, and to being called upon to meet the interministerial committee in regard to its decisions about a client or clients?
We have a policy which we apply both in South Africa and in all jurisdictions where we do business, that we constructively engage with all regulators and with government. So we would never ordinarily decline to meet with any organ of government that would ask for a meeting. We also, at the time, discussed the invitation from the African National Congress, and our view was it was the governing party of the day. It was responsible for policy, and it would be disrespectful to simply decline to go. What transpired in the meeting, of course, is different, but we thought it was appropriate and polite that we, as a major bank, should accept an invitation to talk to the governing party.
So it was not something that Standard Bank viewed as strange to be called upon to account to the headquarters of the governing party for decisions that it made relating to certain clients, and to account to a cabinet ministerial committee in regard to decisions it had taken relating to private clients.
Mr. Chairman, yes, I think we could summarize by saying we thought it inappropriate, but we nevertheless agreed to attend it.
Yes. Mr. Sinton, there are 3 meetings which took place after you have closed the accounts of the Gupta-related companies. The first meeting, you held a meeting with the Oak Bay representatives. Am I correct?
That is correct.
Could you tell the chair who attended the meeting on behalf of Standard Bank and who attended the meeting on behalf of Oak Bay?
Mr. Chairman, may I just give some context? Firstly, we keep talking about closing the accounts. We gave notice in
Of
April
intention, yes.
of our intention to close after a lapse of 2 months. That was to give them an opportunity to find alternative banking facilities. During that period, whilst the 2 month was running out, we had the invitation to meet with the ANC, we had the invitation to meet with the IMC, and we then had a request from the Oak Bay representatives that they meet with us to persuade us to reverse that decision. Is that the meeting that you're talking about?
Yes, that's the meeting that I'm referring to.
Yes, they request the meeting because of the, I suppose, the media interest, the political climate and the like. We agreed to the meeting, not because that we would have met anyway, but it was a fairly senior delegation. The Oak Bay delegation was made up of Nazim Hawa, Terry Renson, Trevor Scott, Ashu Chalwa, Veronica Raghavan. That was the delegation from Oak Bay.
And from Standard Bank?
From Standard Bank, it was David Munro, he was the head of our corporate investment bank at the time. Funeka Montjane, who was head of our retail bank at the time, and still is. Myself as general counsel. Kenny Fiedler, who was head of client coverage at the time. Suzette Hels was head of compliance in corporate investment banking. David Pike was the senior relationship manager, and Vinod Naidu was the relationship manager for many of these actual companies.
And what happened in that meeting?
The Oak Bay delegation argued or made representation to the effect that we should not have made the decision to close the accounts, that all of the adverse information affecting the group of companies all pertained to the Gupta family and Mr. Zuma, that the Gupta family members and Mr. Zuma had all resigned all positions within the Oak Bay group of companies and therefore were no longer able to influence them, and therefore any taint through their association was no longer relevant. They made the submission that they had not been convicted in any court of law for any wrongdoing, all these companies, and therefore it was unfair of the bank to have made a decision to terminate absent that conviction. And finally, and I think for us what was the most relevant was they made the point that they employed some 7,500 people throughout the group, and their ability to pay their wages was being impacted by the closure of accounts, and that would be unfair on those employees to be subject to that, and for that reason also we should reverse our decision. And then they invited us to ask whatever questions we may have about the Oak Bay Group, against a promise by them that they could give us answers which would satisfy us that there was no truth in any of the adverse media information that had been published.
Did you pose those questions?
I asked the questions, yes.
Can you give us the details of the questions and the answers, and whether or not Standard Bank was persuaded by those representations?
Yes, the questions which we asked how they had funded the purchase price of the Ottoman coal mine, and we were told it was from a loan from the Bank of Baroda plus some other funds. The relevance of that was in the context of the request that we hand over the rehabilitation fund to Bank of Baroda as soon as the transaction was finalized. We thought that was suspicious. I pointed out that the Competition Tribunal had published on its website the outcome of the application for approval for the merger. And in that, the tribunal had noted that when they asked the question about what effect the merger would have on jobs at Optimum Coal Mine, the answer was they couldn't say because they had done no due diligence. Now, it occurred to us that for people to buy a mine without doing due diligence and pay over 2 billion rand was an unusual occurrence, and we asked how they could justify doing that. The answer they gave was that the tribunal had misunderstood them, that they had done limited due diligence, but they didn't do enough to know what impact the merger would have on employees. I then referred to the email that we had received from Ronika Raghavan of Oak Bay, in which, and I can quote, she said as the email which says, from Oak Bay, we have presently a 1.456 billion in account 494262, and we would like to move these funds to another bank. Please advise you by send through the instruction. And it came from Oak Bay. We had responded to that these funds were held in a trust, a rehabilitation trust, in our books, that only the trustees of the trust could give instructions to move the funds, and therefore we couldn't respond. At the time of interest was that we conveyed that to them on the 22nd of April 2016. By the 26th of April, that was a Friday, 2 business days later, they produced letters of authority from the Master's office whereby all the trustees have been removed. Appointees of the Guptas have been made trustees of the fund, and they instructed us to move the money to Bank of Baroda. So I asked the question, why did you think it necessary to move such a large sum of money from Standard Bank to the Bank of Baroda? And the answer I got was that because Bank of Baroda offered a better interest rate. Now, we were not satisfied with that answer because nobody had inquired of us as to what interest rate we were actually paying on the account. So we didn't believe the answer. I then asked I mentioned that one Ronika Governor had been reported as being a signatory to the mortgage bond granted by Bank of Baroda to Sinkuma Trust, which was set up by a wife of the president and where the son of the president was a beneficiary. And I asked whether there's any truth.
I'm sorry, Mr. Sinton. Please raise your voice again so I can hear clearly.
Mr. Chair, before Mr. Sinton answers that question, I'm reminded that it's now past the T adjournment, and this is quite an important aspect of the evidence. Is it appropriate for now for us to adjourn now? Would that be convenient?
We can do that, or we let him just give that answer and then we take the break. Maybe he should give that answer and then we take the break.
Mr. Sinton, you may proceed.
Thank you, Mr. Chairman.
Referring to a mortgage bond.
Mr. Chairman, I mentioned earlier that one of the factors we had taken into account in deciding to terminate the account were media reports that the Bank of Baroda had granted a mortgage bond to a trust of which a wife of the president was the sole trustee and a son of the president was a beneficiary.
Who is the president that you're referring to?
President Zuma. And those reports said that Westall Investments, a customer of Standard Bank, had guaranteed the repayment of that loan. And I asked the representative of the meeting, Ronika Raghavan, if she was the same Ronika Governor, and she confirmed that it was. Governor was her maiden name. So I asked her if there was any truth in these, in the correctness of what had been reported. Her answer was to the effect that she had never met any wife of the president, let alone being party to arranging a loan to her or a trust on her behalf. I then mentioned the fact that her signature appeared as a witness on the mortgage bond itself, in which event she, after a lengthy pause, recalled that she had in fact been responsible. She had arranged that loan. Again, the initial denial followed by the admission for us left us completely unsatisfied with the answer. We then asked who, by that stage we'd had the meeting with the ANC, we asked who had asked the ANC to intervene to protect Oak Bay's interests, and Mr. Howard confirmed that he had done it. He had asked the ANC to intervene on their behalf. And he similarly said that he had also written letters to various people in government and the president asking them to intervene on their behalf. In our meeting with the ANC, we were asked to comment on the allegation that we were part of white monopoly capital, and this closing the accounts was a campaign of ours to drive black people out of business in South Africa. We dealt with that in that meeting, but I asked the Oak Bay delegates who was responsible for this notion of, on what basis they'd come to the conclusion that they had accused us of being part of this conspiracy, and they refused to give an answer to that question. And then finally, I referred them to the fact that when they took over Optimum Coal Mine were banked with Standard Bank. They'd banked Standard Bank for many years, as had Glencore. And because we were bankers, we've been given a copy of the share sale agreement, whereby Tegeta Exploration Resources had purchased Optimum Coal Mine from Optimum Coal Holdings. And from a perusal of the share sale agreement, it can be seen that the price for the shares was actually R1. That was what they paid for the shares. They then were required by Glencore sensibly to repay the banks who were owed about 2.1 billion rand, because Glencore, or the subsidiary of Glencore, had stood surety for that, so they needed to get released from that. But there was another condition precedent to the sale, and that is that Tegeta procure that Eskom release the Glencore subsidiary from its surety obligations, which made sense, but also from a claim for about 2.1 billion rands worth of penalties, which had been invoked by Eskom for allegedly defective coal. So the question I posed was, what value, what consideration did you give Eskom for effectively waiving a 2.1 billion rand claim against the biggest mining company on the planet? And the answer was none. They were not required to give any value to get that released. We were not satisfied with that answer either.
And having regard to all those answers and representations and a number of factors that you took into account, you were not, Standard Bank was not persuaded to reopen the accounts.
That is correct.
Thank you very much. We'll take the tea adjournment now, and we will resume at 20 to 12.
first came to the Western Cape in 1653.
Okay, you may proceed, Mr. Mkwena.
Thank you, Mr. Chair. Mr. Sinton, before the tea adjournment, you were dealing with your meeting, with the Standard Bank meeting, the meeting between Standard Bank and Oak Bay representatives. Is there anything that you need to add? Yes. Now, can we move on to the meeting which you mentioned?
I'm sorry, Mr. Mukwena. I think he must just repeat that answer. I think his mic was off, so it goes into the record.
Mr. Chairman, yes, I have nothing more of particular importance to say about that meeting.
Yes. Now, let's move to another meeting which you mentioned in passing before the tea adjournment. You referred to the meeting which was held between Standard Bank and the NEC of the ANC. Am I correct?
That is correct.
Yes. Who called that meeting?
My understanding, it was a request from the Secretary General of the ANC, Mr. Mantashe, made to Mr. Sim Chabalala, who is the Chief Executive of Standard Bank.
And then where was the meeting held?
At Luthuli House.
Who represented Standard Bank? If you are able to recall.
The Standard Bank was represented by myself, Mr. Sim Chabalala, and Ms. Hannah Siddiqui, who was a senior executive in our retail banking division.
And then ANC was represented by who?
ANC was represented by Mr. Mantashe, Ms. Jessie Duarte, and Mr. Enoch Ngodongwana.
Prior to attending the meeting, were you told as to what was the purpose of the meeting?
I was told it was to discuss the notice of closure of the Gupta-related accounts.
Now, could you please tell us what happened in that meeting?
When the meeting commenced, after we had exchanged the normal pleasantries, we made it clear to the ANC representatives that we were not in a position legally to discuss the affairs of any of our customers, and in particular we were not in a position to discuss the Gupta-related entities, the Oak Bay companies, or our reasons for closing their accounts, but we were willing to explain our policies and procedures around account closing generally. And the ANC representatives seemed to accept that would be an appropriate way to proceed with the meeting.
And then what happened in the meeting? Can you share with us?
Well, I then explained to the meeting essentially what I explained to the chairman here about the local and international obligations that we have, about our processes when we come across adverse information and how we make our decisions. I also took the opportunity to highlight the real risk for us. We had an unfortunate experience where our bank in Tanzania, whilst it was negotiating to get a mandate from the government, employed a local partner that was partly owned by a politically exposed person, which is the term we use in these issues. And the mandate was awarded, the partner was paid its fee in US dollars, and the partner, being a corporate partner, withdrew that fee in cash. As a result of that fact alone, the Serious Fraud Office in the United Kingdom opened an investigation of corruption against us, and the Department of Justice in the United States opened a case of corruption against us, based simply on the fact that a local partner had been employed. And we explained that we cooperated with both the Department of Justice in the United States, we cooperated with the Serious Fraud Office, and the result was a deferred prosecution agreement, which is effectively a settlement agreement with the authorities, whereby we ended up paying about 38 million US dollars in penalties and fines for simply being having employed a local partner, and that deferred prosecution agreement had to be approved by the courts in the United Kingdom. And the judge who approved it said that the prosecution was justified simply on the basis that our staff should have foreseen the possibility that their local partner, being part-owned by PREPS, would be sharing the fee with people in government. We should have foreseen that as a possibility and therefore not employed them at all. The fact that we employed them rendered us guilty, as far as they were concerned, both in the United Kingdom and the United States. So I explained this to the meeting, and said we therefore are highly sensitive to the possibility of dealing with people who could be using our systems and facilities for gratification. I think the term is in the local term. But having explained all of that, the meeting then did go on to talk about the issue of the close of the Gupta accounts. We were asked to comment on the perception that we were part of white monopoly capital oppressing black business. We were asked to comment on the reports that we were taking instructions from people in Stellenbosch in closing these accounts. And we obviously rejected those out of hand. I must say it's the first time I've seen my boss, Sim Chabalala, get really angry. We were then also asked to comment about the concerns that these account closures might have for the employees, i.e. The inability of the Oak Bay entities to possibly pay their staff could affect the staff adversely, and we needed to comment on that. And I think our answer at the time was the fact that we were simply complying with the law and taking necessary steps to protect us. And the point that I think Sim made at the time was we employ 40,000 people. Our staff are equally important to us. And we can't do anything that is contrary to the law here and exposes us to international sanctions.
Yes. After the meeting, you did send a letter to the ANC. Am I correct?
Yes, we did. The entire meeting was oral. There were no presentations made, no documents exchanged. So we thought it appropriate to send a letter just to summarize what we had said in the meeting, so we both had a clear understanding.
May I refer you to page 138 of Exhibit H1? Are you there, Mr. Sinton?
That is the letter that was
sent. Is that the
sent,
letter?
yes. Correct.
Yes. And the letter captures what you have already informed the chairperson in your testimony, briefly.
Yes, I believe it does, Mr. Chairman.
Now, you also mentioned in passing before the T adjournment that Standard Bank was invited to the meeting by a committee that was chaired by Mr. Musebenzi Zwane. Do you recall?
Yes, I do.
Yes. Now, how did Standard Bank became aware of the existence of the committee that was chaired by Mr. Zwane?
We received at Standard Bank an email from an advocate, Zarina Kellerman, who addressed to Mr. Ben Kruger, who at the time was the chief executive of Standard Bank Group, i.e. our group holding company, in which he said that she acts on behalf of an interministerial committee and that Ben Kruger was invited to a meeting to discuss the closure of accounts.
Did Standard Bank attend that meeting?
Yes. We responded by pointing out that Ben Kruger was not the appropriate person. This was a matter involving the Standard Bank of South Africa Limited, i.e. our South African bank, and the correct person to therefore engage with the IMC was Mr. Sim Chabalala, and he and I attended a meeting in Pretoria as a result.
And who represented the committee that was chaired by Mr. Zwane?
When we arrived at the meeting, there were 3 people attending the meeting on behalf of the IMC. There was Minister Zwane, Minister Olifant, and Mr. Jimmy Manye.
Was Mr. Jimmy Manye a minister at the time?
No, we asked on what basis he was attending, and he told us that he was an advisor to the ministers.
Did he remain in attendance throughout the meeting?
Yes, he did.
Now, were you informed as to how this committee was established?
The Minister Zwane introduced himself at the start of the meeting as being, he described that the committee had been formed by cabinet at the instance of President Zuma, and he had been appointed as chairman, and therefore he would be conducting the meeting in that capacity.
Were you informed about the agenda of the meeting?
We understood the purpose of the meeting to be to discuss the closure of the Gupta-related bank accounts. The meeting took place on about the 5th of May 2016, so it was during the period when the notice period was still running its course. So our understanding was it was to discuss the closing of bank accounts.
Could you share with the chair in your own words as to what happened during the meeting?
Mr. Chairman, we started the meeting by, as we had done with the ANC, making it clear that we're willing to discuss and explain to the committee the policies and procedures that we adopt as Standard Bank when we have adverse information in the public domain. And we, again, as we had done with the ANC, explained why as Standard Bank we are particularly sensitive to this issue. I might mention, because I omitted to say so earlier, that when we concluded the deferred prosecution agreement with the Serious Fraud Office in the United Kingdom, the charge that was leveled against our bank in the United Kingdom was that it had failed to prevent an act of corruption by an associate. So there was no allegation that Standard Bank London had done was itself corrupt, but it had failed to prevent an associate from corruption. In the nature of a deferred prosecution agreement, the agreement sanctioned by a court says we will allow you, the agreement is you will pay a voluntary fine, you will compensate all people who have suffered loss as a result of the conduct complained of, and you will undertake a remedial program to ensure that this type of conduct never happens again. And if after 3 years you are not charged with a similar offense, then the charges will lapse, i.e. it's a non-prosecutorial outcome. It's as if the charges had never been laid. So our bank in London had this 3-year probationary period where it had to be exceptionally careful about what it did and said in connection with bribing corruption, and it had to be very careful to ensure that its associates did not in any way become accused of bribing corruption. Now, there's such a close relationship between all of the banks within the Standard Bank Group that it would be not difficult to argue that our bank here is an associate of our bank in London. So we had to be particularly careful about not being caught up in bribing corruption in South Africa. And I explained all of this to the IMC, and they accepted those explanations. However, once I had given that explanation, they turned almost immediately to the Oak Bay entities and the closure of the accounts. And the the point they made, they said that Oak Bay has, they claimed, had about 7,500 employees. They say you can safely assume in South Africa that most employed people have more than 5 dependents, and therefore up to 60,000 South Africans, they said, could be, if this decision was implemented, adversely affected in that they might be deprived of income or payment. And we should, as a responsible bank, be sensitive to that and should reconsider for that reason. And our response was to say we really are doing no more than complying with what we think is a very onerous law. We really are very concerned if people should be affected by those decisions, but it's really the conduct of the owners and managers of the business that have brought them to that situation, not us. So that was the one representation they made. In that same line, they said, well, surely if it's a contest, as it were, between the well-being of the employees and their dependents or compliance with the law, we should favor the dependents, i.e. we should keep the accounts open to enable the dependents to be paid and risk non-compliance with the law. That was the proposition they put to us. And we said we couldn't accept that. We wouldn't accept that we would knowingly break the law in order to ameliorate the consequences of non-payment of employees. They then suggested that the banks should not be allowed to close bank accounts altogether, i.e. they said they had the power to change the law and that they would consider recommending changes to the law to make it illegal for banks to close accounts. Minister Zwane. Minister Zwane in the meeting.
Can you repeat what did he say?
He said that as a member of the ruling party, he had the ability to get the law changed, and he was inclined to propose a change in the law whereby it would become illegal for banks to close accounts in these circumstances.
Yes.
And who said that if, in effect, you had to choose between not complying with the law and having workers lose their jobs, you should not comply with the law, if I understood your evidence correctly?
Mr. Chairman, regrettably, I can't remember which of the two ministers said that, but that was the proposition put to us.
But it was one of the ministers.
That is correct, Mr. Chairman.
Thank you.
Yes, Mr. Sintin, proceed then. What was, share with us further engagements between yourself and the committee in that meeting?
I think I've already mentioned we were asked to comment on the allegation that we had colluded with the other banks in closing accounts, and we said that definitely was not the case. We were asked to comment on the allegation that we were representing white monopoly capital in closing accounts, and we rejected that. We were asked why it is that we bank construction companies that have been fined for collusion in the building of soccer stadia, yet we close the bank accounts of entities that have not been convicted of any offense. And we responded by saying that we didn't admit or deny that we did bank any construction companies, but we would regard an administrative fine for collusion as something quite different to money laundering or corruption. Towards the end of the meeting, they reminded us that as a bank, we operate under a license granted by government, and that they suggested we should be more responsive to concerns that they were raising on behalf of government.
Do you recall as to who said that?
Mr. Zwane, that was his submission.
And what was the response from Standard Bank when he said that?
We said, as far as we are concerned, we comply with all of the laws of the land to the best of our ability at all times, and if the law should change, we would adapt. So in summary, that was really the tone of the meeting. The meeting ended with Mr. Zwane, or Minister Zwane, asking us what changes we would need to see within the ownership and management of the Oak Bay Group of companies that would be sufficient to persuade us to reverse our decision to terminate the accounts.
So despite you having informed Mr. Zwane that you are not at liberty to discuss the customer relationship with the IMC, he continued to put those questions to you?
That is correct.
Now, after the meeting, what was...
I'm sorry, Ms. Mukwana, and what was your answer? I didn't hear in terms of that last question from Minister Zwane.
Mr. Chairman, our response was to say that we had taken the decision based upon the facts as presented to us, that if circumstances should change or facts could change, we might have to make other decisions, but at that point in time, we were operating on information at hand.
What impression did you gain after this meeting, Mr. Sinton? You must have reflected about what transpired in the meeting between the Standard Bank and IMC. What impression did you gain about this meeting?
The meeting was an attempt by two cabinet ministers on behalf of cabinet to persuade us to retract our decision to close the accounts of the Gupta-related entities. There was no other reason for that meeting.
And if your analysis of the discussions, or rather, if your analysis of the purpose of the meeting is correct, then the position might not only be that two cabinet ministers wanted a meeting with Standard Bank to try and get Standard Bank to reverse its decision, but it might mean that if that committee was established by cabinet, it might mean that cabinet wanted a meeting with Standard Bank through that subcommittee to achieve a reversal of Standard Bank's decision in the particular matter. Is that right?
That would be correct, Mr. Chairman.
Now, were there any minutes which were taken during this meeting by the committee?
Advocate, well, she was described as Advocate Kilby, the secretary to the committee, was present throughout. She seemed to be taking notes, but after the meeting, no notes were, or minutes were circulated at all. We were concerned that this was, in effect, a meeting between Standard Bank and a subcommittee of cabinet, and therefore it ought to be formalized in some way. And so we took it upon ourselves to, as we had done with the ANC, write a letter to the ministers to record what oral representations and presentations and explanations we had given during the meeting.
May I refer you to page 148?
Page
148, Mr. Chair. Would that be the email wherein you enclosed the letter on page 1, starting from page 149?
That is the email that was sent to the committee, yes.
And then in the email, you say that please find attached documents for attention of Minister Zwane and Oliphant. And what is attached is the letter on 149. Am I correct?
That is correct.
Now, Mr. Sinton, are you able to summarize without having to read the contents of the letter on page 149 as to what did you convey, or what did Standard Bank convey to Minister Oliphant and Minister Zwane?
It records in more detail, Mr. Chairman, what I've just described to you now.
Okay.
It up front reminds the ministers that we had hoped to keep the meeting about policy and practice, not any particular customers, but we did go on to discuss particular customers. It summarized all the laws that we say are applicable to us and the risk we face if we don't strictly adhere to those laws. We summarized our experience of international views on dealing with bribery and corruption. And we then described our process and about what considerations we take into account when we make a decision to close, i.e. they're not arbitrary or capricious decisions, they're carefully considered. And effectively, we finished off with the wording where I say in response, when I say I was letter was signed by Sim Chabalala, I obviously had a hand in drafting it. In response to a closing query as to whether there's any possibility of Standard Bank reversing any decisions that could help save the jobs of the employees of Oak Bay / the Guptas, Standard Bank indicated it applies the known facts and suspicions as envisaged by Precker and Poker to the law to reach its decisions, and therefore if the facts should change, there could be a resultant review. Consequently, the IMC requested, and Standard Bank indicated willingness that Standard Bank give consideration to informing the IMC in due course of what changes in ownership and or control of the Oak Bay Estate Gupta Group of companies could be required for Standard Bank to review any decisions it may have made. And then there's a sort of normal sort of caveat.
Mr. Sintin, this is quite a detailed letter addressing a number of issues. Was these issues that are contained in this letter at any stage disputed by Minister Zwane or Minister Oliphant or by anyone?
No, we received an email back from the Secretary to the IMC wherein she was asked to thank us for the input, and that's the only response we received to the letter.
Would that be the email contained on page 154?
It is.
Other than that short email, nothing was communicated to Standard Bank about the contents of Annexure SB 16.
That is correct.
Now, subsequent to that meeting, you would recall that there was a press statement or an announcement made by Minister Zwane. Do you recall?
I do recall that, yes.
Could you share with the chairperson what was contained in that media statement and what was the purpose of that media statement? You are dealing with it from page 11111, paragraph 31.1 to paragraph 31.5 of your statement. If you can summarize for us what was conveyed in the press or in the media statement.
Did you say 121?
111, Mr. Chair.
Sorry?
111.
Oh, thank you.
Yes, in 111, on page 111 is my summary, my witness statement of, I quote the extracts from the statement, Mr.
Yes,
Chairman,
if you can.
If you look at page 142 of the bundle, you'll see the statement itself.
Yes.
Where of relevance to this discussion is where it was said on behalf of the Department of Mineral Resources that on 13 April 2016, Cabinet established an interministerial committee to consider allegations that certain banks and other institutions acted unilaterally and in collusion when they closed bank accounts and or terminated contractual relationship with Oak Bay Investments. That was the purported purpose of this meeting. And then they go on to make recommendations for a judicial commission of inquiry into the closing of accounts and various other things.
And this was coming from the office of Minister Zwane.
Yes.
Subsequent to this statement that has been made, we now know, when reading your witness statement, that there was a media statement made by the then President Zuma in relation to the contents of the statement made by Minister Zwane. Do you recall?
I do recall that, yes.
And can you share with us what was conveyed in that media statement?
Yes, on you'll find the actual statement at page 155 of the bundle.
Annexure SB 18.
Mr. Chairman, where you'll see it's a statement. The heading is Statement of Minister of Mineral Resources is not government position. And the heading is the Presidency wishes to assure the public, the banking sector, as well as domestic and international investors of government's unwavering commitment to the letter and spirit of the country's constitution, as well as in the sound fiscal and economic fundamentals that underpin our economy. And they're going to say that the statement issued by the Minister of Mineral Resources, Mr. Zwane, yesterday on the work of the task team established to consider the implications of the decisions of certain banks and audit firms to close down the accounts and withdraw audit services from the company named Oak Bay Investments was issued in his personal capacity and not on behalf of the task team or cabinet. That was.
So the President there was repudiating the media statement that was made by Mr. Zwane.
Yes, that seems so.
Is it your understanding too that the statement that was issued by the Presidency at 155, while it may have repudiated the statement, media statement issued by Minister Zwane, it acknowledged that he was a member of the task team? Well, maybe I can help you if you look at the third paragraph of the statement. The paragraphs are not numbered. It says Minister Zwane is a member of the task team.
That is correct, Mr. Chairman.
So it appears that officially the statement doesn't deny the existence of a task team as such, but it repudiates the media statement that was made.
Yes, that was our interpretation of it, Mr. Chairman.
Thank you.
Now, Mr. Sinton, having gone through your statement and the annexures and provided oral testimony before the chair, are you aware, and I'm asking this question flowing from your experience within the banking sector, whether are you aware of any provision in the Constitution that could have entitled the executive to interfere with the bank-client relationship?
I certainly am not aware of any statute or law which allows for it. And I would assume that the provisions of the Executive Members Ethics Act, which prohibit executives from using their powers to benefit any one person, would in fact prohibit it.
May I refer you to page 115 of your statement in order to conclude your evidence. In paragraph 39.1 on page 115, you state that where Standard Bank has terminated its relationship with the Gupta entities in order to avoid contraventions of and therefore in compliance with legislation, not any minister or executive or any judicial commission or inquiry can lawfully direct that the terminated relationship be reinstated. And you confirm that?
I can confirm that.
Yes.
I must hasten to add that I do say at the outset that what I say about legal conclusions is based on legal advice, but I do say that.
Mr. Sinton, please try and raise your voice again. I think it's natural. Sometimes one speaks at a certain level and then later on goes down. But if you do no more than what you did earlier on when I asked you to try and raise it, that would be enough.
Thank you, Mr. Chairman. I will.
Thank you.
Must I repeat my answer, Mr. Chairman?
No, that's fine. That's fine.
Lastly, Mr. Sinton, you annex to your statement, may I refer to page 158, where you are annexing the transcript of the proceedings of Parliament. And this will also assist in clarifying the questions that the chair was posing around Mr. Zwane's involvement as the member of the IMC. Now, without having to read it, Mr. Sinton, you have dealt with this in your statement. What was the purpose of you annexing that transcript? What does it convey in the light of the issues that you wanted to convey to the chair?
Mr. Chairman, I have already given evidence and we've discussed how we were invited by the IMC to a meeting. Mr. Zwane, or his ministry, then issued that statement saying that the recommendations of the IMC to Cabinet had been accepted and what those recommendations were. He was then repudiated to a degree by the presidency. When we were faced with the application by the Minister of Finance in the Pretoria High Court for his declaratory order, we gave consideration to whether we could regard the workings of this interministerial committee as having come to an end or been rendered of no relevance to us by that repudiation. And in our research, we obtained this transcript, which is a transcript of the goings on in Parliament in November 2016. And our interpretation of the questions posed to President Zuma at the time and his reply was to the effect that whilst Minister Zwane had been repudiated for having issued that statement, the recommendations of his interministerial committee were still being considered by him as president. And we could still, in due course, expect to receive some other response. And so the purpose of referring to it was simply to tell the court that it may have been at the time not the end of the matter as regards the meetings with the interministerial committee and its recommendations.
Mr. Chair, for completeness, Mr. Sinton is dealing with those aspects from page 114 of his witness statement, paragraph 37 to paragraph 38.
Thank you.
Subject to any questions from the chair, though that concludes the questions for Mr. Sinton.
Maybe just one question, Mr. Sinton. Are you aware whether Minister Zwane had ever said anything in public about his statement that had been repudiated by the president, or he didn't say anything publicly that you are aware of?
Mr. Chairman, the only public statement I'm aware of, you can find at page 156 of the bundle. That appears to be a report in City Press on questions and answers in Parliament, where the report, if two-thirds of the way down, says the presidency distanced itself from Zwane's statement, saying he had issued it in his personal capacity and that the contents of the statement were not the government's position. DA MP David Mania asked Zwane whether he would resign from the cabinet and when he would do so. Zwane would not answer the question directly. He said in terms of the principle of separation of powers, the matter belonged to cabinet and not to parliament, adding that Mania had no jurisdiction to ask him whether he would resign. And then they purport to quote from Mr. Zwane, as I stated during my interview with the SABC, I stated that the matter of inquiry, which Mania seems to be problematizing, can only be decided by the President once he has sufficiently applied his mind to the matter. We have been a record in this matter. It is indeed unprecedented that banks can unilaterally close accounts. The matter can therefore not be left hanging, said Zwane. That's the only public commentary I'm aware of.
Thank you very much. Thank you, Mr. Sinton. You will be released for now, but it's likely that the legal team may ask you to come back at some stage. But thank you very much for coming to give your evidence in the commission. Thank you very much.
Thank you, Mr. Chairman.
You are excused.
Chair, the next witness has been arranged for tomorrow morning. Would it be appropriate to adjourn?
Yeah, that's fine. We will then adjourn the proceedings, and as I indicated, tomorrow we'll start at 11:30 and not at 10, as we normally do. The proceedings are adjourned.